was on end.
Yes.
And that list was the list from which suppliers and contractors were chosen in November and December and part of January 2010 and 2011. Correct.
That is the list that came as a result of the earlier dispute by contractors when we had actually said the work must start earlier in August. ESCO gave that decision, and there was a dispute declared by these other contractors, so the whole process had to be stopped.
So I was hoping we wouldn't have to
go
down there again. But I can't stop you if you wish to go down there again. All I can say, well, let me stand back. You give your evidence.
Maybe it would have helped me to hear what the leader of evidence wants to say.
Yes, all right. I'll try and help, but it's not very helpful. We've studied the evidence of that day closely. And there is not one consistent version, but there, on our calculation, varying versions that total about 7 in total. And I'm not going to go through them because we would spend weeks here. The evidence that you gave, understandably, is evidence from your own recollection 10 years ago.
Yes.
And I think you will concede that during the course of the day it differed from time to time. You corrected yourself, different explanations were given. But you agree with that, because you nod?
No, I do agree, Chair.
Yes. That list of 106, we eventually learnt from your later versions that it was not the list presented to EXCO on the 30th of June 2010. It was a later list compiled and signed by you in October. Can we settle for that, at least?
We can settle for that, provided would say it also contained some of the contractors that were there in the list of June.
Well, whether it did or not, there were 23 of those contractors that we know from the Open Waters report.
Yes.
But there were 83 others that came from various sources, and I'll give you some detail in that regard.
Yes.
But what I want to put to you for the moment is not the checkered history of that list, to put it at its lowest, but simply to tell you what Mr. Mokoena said and ask for your comment.
Okay.
Mr. Mokoena said that he queried with you that on that list were many companies or contractors that he was seeing for the first time. And he asked, why are there so many new contractors on this list? And you responded, according to Mr. Mokoena, by saying, this is my list, or this is my plan, and I have the power to allocate.
I deny that fact.
And he said that after the war room meetings, that you made allocations of contracts to contractors and suppliers.
I deny that fact, Chair.
That was also a finding of Mr. Advocate van Graan after reviewing the evidence put before him. That evidence was confirmed by Mr. Makatwa, who said that you chose contractors that would be allocated units to build.
Mr. Makatwa would have never been with me at any moment, as I've indicated, Chair. Our interaction was with HOD. I wouldn't understand how would he know, at least, to say the least, about what he's saying.
We dealt with this last time very briefly, and I think your response to the proposition, which is important now to raise in respect of questions I'm about to put, was that on that list there were a number of contractors who had not been part of the group of contractors that submitted bids in the open tender process in April 2010. You said you didn't know about that. Do you recall that?
That is correct, Chair.
There were also a number of contractors who had been disqualified during that process. Do you know anything about that?
No, Chair.
Well, we've compared the bidders list and the documentation relating to that process, the bid evaluation committee documents and the bid adjudication committee documents, and we've compared that with a list of 106. I'm not going to go through those lists with you, but merely to say there was a material number of people who did not partake in that process, who found their way onto the list of 106. And there were, in addition, people who had been disqualified. There was some discussion, you nod your head, we've established that, or we've established that you don't know anything about that, can't contest it. But there was a discussion at the last hearing that perhaps that list of 106 comprised those people who had passed the threshold of acceptance in the tender process. And I just want to put to you that's not correct on our research. And we'll put the detail in our submissions.
That was my assumption, as you will remember, Chair, when I was asked my understanding of the list I've signed. I've said those lists should have been composed of all the contractors who have passed the test. That's what I said in this commission, and I want to stand with that.
All right. Well, an examination of the lists will show what it shows. And that, in fact, is confirmed in the Open Waters report. And just for the record, if I could give a reference, it's at FS 15, page 537 and following, paragraph 7.6, where those particular bidders are listed, or people who didn't bid are listed, and people who did bid and were disqualified are listed. Now, according to the investigators and the evidence leaders' examination of these various lists, we found a number of contractors who found their way onto the list of 106 but didn't tender at all in the open bidding process. And two of those were Rob's Construction and Tutela Bacholo. Do you know of those entities?
No.
Right. Mr. Mokoena, in his statement, said that on that list of 106, he didn't recognize the first 6 contractors that were recorded on that list. He remembers the names of 3 of them. That's Alatori, Quena Property Developers, and Raloto Properties. Do you recall the names of those contractors?
No.
Mr. Mokoena, he put it as a belief. He had no more than a belief based on what I will put to you, that these contractors were close to you, Mr. Zwane, because you called Mokoena personally to expedite their payments. What do you say about, you've read Mr. Mokwena's evidence, what do you say about that?
I deny that evidence, Chair.
He also says, or Mr. Mokesi said in the founding affidavit in the review proceedings, that it would have been irregular for an MEC to be involved in the appointment of contractors. You would concede that?
That's what I've been saying all along, Chair.
Let's just deal with Rob's Construction for a moment, and I want to put to you what the investigators have found during the course of their investigations. Rob's Construction, with that name, appears on the list of 106. I presume you don't contest that.
I would not contest any name appearing on the list that I've signed.
And they do not appear on the Bid Evaluation Committee minutes, which is a full list of all those who tendered. So the allocation list reference, Chair, is FS 14, 224 and 225. That's where Rob Construction name would appear on the list at those pages. And the Bid Evaluation Committee minutes appear at FS 20, page 63. All this will be summarized in the work yet to be done by the legal team, Chair. The investigators go further in their report to say that Rob's Construction appears to be a trading name for Rob's Investment Holdings Pty Limited. Do you know anything about that?
No, Chair.
And the reason they say that is in a later tender, Rob's Investment Holdings Pty Limited included housing allocations given to Rob's Construction as part of its own experience. So it cited Rob's Construction as part of Rob's Investment Holdings experience. So they're related companies according to the researchers.
Okay.
You understand the proposition?
I understand, Chair.
Rob's Bricks received a payment of 7 million rand. It's not clear whether that was as a material supplier or not. That payment is shown in the investigators' report at FS 20, page 203 to 205, Chair. So the investigators have concluded that Rob's Bricks and Rob's Investment Holdings are associated and part of that association would include Rob's Construction. Do you know Mr. Blackie Seoe, S-E-O-E? Seoe.
Yes, I know him, Chair.
Do you know that he was the sole director of Rob's Investment Holdings at the time?
No, Chair.
That also appears in the supplementary investigators.
Well, do you know, even if you don't know that he may have been the sole director, do you know him to have been a director of that entity?
I know him, Chair, as somebody who was very close to sports, especially boxing. If I'm not mistaken, I think at a particular time he participated, because I used to see him in that kind of an activity. I know he's from Free State also.
Oh, but you don't know him to be connected to any particular company or entity?
No, I wouldn't know his companies.
Yeah. Okay.
I wouldn't.
All right. Okay.
The relevant references, just for the record for the moment, Chair, appear at FS 21827 and FS 21832-3. That, by way of background, we know from the researchers of the investigators that Rob's Construction received housing allocations towards the end of 2010, beginning of 2011. Do you know that for a fact or not?
Outside the 106.
No, they were on the 106.
And then they received other allocation.
No, and as a result of being on that list, they received housing allocations.
My recollection is that all the 106 contractors should have been allocated.
Right, so you wouldn't have a problem with the fact that if Rob's Construction were on that list, they received allocations.
I wouldn't have had a problem with any contractor, Chair,
Yes.
on that list, because I would have assumed that it had gone through processes and it's correct for them to be there.
Well, we know that they didn't go through the open tender process, and they weren't on that resultant database. But let me just put that to you as a fact. I don't want to go back into the database. The 106 is a journey enough for the moment. Unless, of course, you want to go there. Of course, you're entitled to do so. But anyway, let me just take the story a little further. Blackie Siowe and Mr. Magashule were co-directors of an entity called Sambal, S-A-M-B-A-L Investments. Did you know that?
No, I don't, Chair.
Yes. That evidence comes from the transcript of an interview that the investigators had with Mr. Siowe. He's since deceased, recently deceased. So it's a transcript of an investigator interview. For the record again, FS 13388389. So the CIPC, the official records show that Mr. Magashule and Blackie Siowe were former directors in a company together. But we know too, from FS 12391.31, that a payment was made from Rob's Investment Holdings to Ms. Chiloto in the Premier's office. And that receipt was acknowledged by Ms. Chiloto. So we know that without a formal process, a company received a benefit as a contractor towards the end of 2010, that there was some association, business association between the director of that company, although you don't know that, and Mr. Magashule, and that subsequently a payment was made from Rob's Investment Holdings to the Office of the Premier. Do you know anything about that?
No, Chair. I only saw the transcripts in these documents, but prior to that, I did not know anything.
Right. And interviews have been held with the person of Rob's Investment Holdings who made the payment, Mr. Mtwentula. Do you know him?
Mr.?
Mtwentula, M-T-W-E-N-T-U-L-A.
No, Chair.
All right. Chair, all that information is contained in the investigator's report in some detail. You recall that at the last hearing we spoke about a person, Rochelle Else. Do you recall that?
Rochelle.
Yes. Do you know who she was?
I've met Rochelle, I think when we were inspecting some houses.
Yes, she is a member of the Tutela Bogolo Trading Enterprise, CC, an entity which also appeared on the 106 list, but did not appear on the Bid Evaluation Committee lists as a tenderer. She received a housing allocation, and Mr. Mkwena's evidence is that he believed that Rochelle Else was close to Mr. Magashule. We've dealt with that, do you recall?
Yes, I recall, Chair.
Right. And the reason given by Mr. Mkwena for that evidence was that because you, Mr. Zwane, used to tell Mr. Mkwena that Mr. Magashule had said that Else should be appointed and her claims should be expedited. What do you say about that?
I can put it in this commission that the HOD Gift Mkwena was more close to the former Premier than me. I think if there was an issue of that nature, that issue would be communicated with him, not me. as he have indicated in this commission, of how far they come, both of them.
We've also since obtained a second affidavit of Mr. Mokoena, and again, I must put it to you, although I don't want to revisit the evidence of the last hearing, but if you wish to do so, of course you may. Mr. Mokoena says, yes, indeed, a database of eligible contractors was kept, that there was a database that was kept. But he said it was never the position that someone could just be given a contract because they appeared on the database, or that one's presence or listing on a database entitled one to receive an allocation of houses to be built and the like. The purpose of a database was to notify people on the database, or to notify entities on the database, that a tender was going to be issued and that they could then tender in a formal process. Have you read that affidavit?
Yes, I have.
What do you say about that?
I find it very strange, Chair.
Well-
In fact, other evidences, including Muso Zwane's evidence, would say they will go out for tenders, and those tenders will be adjudicated and become a database where work will be allocated for the next 5 years for those contractors that appear on the tender, and that is what I was told.
Well,
when
there's
I
a
arrived.
fundamental difference between you and Mr. Mokoena on that, because what Mr. Mokoena says in his affidavit is you could be invited through an advertisement process to express interest in appearing on a database, but thereafter the allocation of work would depend on a fair procurement system.
Well, Chair, that's not what I was told. That process lies with him when he was an HOD. Mr. Mokoena was there in 2004 when this other process did take place. So I wouldn't dwell much in terms of how they administered administratively, because that was not my space, and I've never interfered with that space. If an open tender was called for, I had all supported it. If they came back with a database giving me reasons, as the people who have been there, I've never given them a problem, but I'm saying officials who have been there longer than me are giving different versions of how the department used to perform there.
Of course, you did testify that although you might not, when you came to the department, you might not have known about the Housing Act, you did know about the PFMA, and you did know about the PFMA, and you had an understanding of that. Is that correct? Is my recollection of your evidence correct?
I corrected myself, Chair,
Yes.
on the 12th of October,
Yes,
that I'd seen the Housing Act,
yes.
and I knew about it. I was told about it,
Yes.
although I relied more on the PFMA,
Yeah.
because I was from the municipality.
Yes.
Yes, the section 6.3, I was taken aboard on those sections where the MEC administered and so forth and so on.
Yeah, okay.
Yes,
You are saying that your last evidence was that
I corrected it.
you corrected yourself and you said you knew about the Housing Act.
Yes.
Is that right?
Yes, Chair.
Okay, and you had an understanding of it, or you just knew about it?
I understand
Housing
that.
Act.
I understand it.
You understood it as well?
Yes, I understood it.
Okay, all right. But my focus is the PFMA.
Yes.
Am I correct in understanding that what you said last time was that you had an understanding of the requirements of the PFMA?
That is correct, Chair.
Yes. Now, was it your understanding that if there is a database, if there are companies who are on the department's database, there is no need to go on open tender? Or was your understanding that the two are not inconsistent with each other? The fact that you have a database of companies doesn't exempt you from going on open tender when you are supposed to go on open tender. What was your own understanding of the position?
I think it will help us, Chair, to separate the database as it appears on the PFMA, because it will have limitations in terms of the amounts and so forth. And maybe try to understand how the database used by the Department of Housing at that particular time used to be done. A competitive process would be entered into, like the Constitution and other relevant acts would want. And out of that action, instead of looking for 10 contractors that are going to get a job for that particular year, you go and look for 150. And then you come back and put all these contractors that have undergone that competitive process to be on your list, which is famously called the database.
Yes, yeah.
But
the list.
The list.
Yeah.
This is the list that even the evidence of some of people who were here was saying for the next 5 years, that list will be used. Maybe for the purpose of this commission, let's use the word list.
Yes.
And that list will be used until it expires in the next 5 years.
Yes.
And so because that had followed a competitive process, that's how things were happening when I came there. And I expressed at some point a view, I must say, which is not in my evidence, that why is that so? Why can't we, every time when we have a project, go through this process?
Open tender process.
Yes. They said there's no time when we are not building houses in this department, whether unfinished houses or new houses. Now, if you are year after year going to be entering into this process, it takes time and we are not going to finish. So this is how we are doing it here. And I then understood what they were saying. And that is what I aligned myself with when I was there.
Okay, just to summarize that, am I correct in saying what you are saying is, after talking to them about this database or list phenomenon,
Yes.
your understanding was that once companies or entities had been included in the database or in the list, One, that would be for 5 years,
That is correct, Chair.
and two, there would be no open tender process in respect of each project that might come up
Within the 5 years.
within the 5 years. But your understanding was that before a company or companies were put onto the database, there would be a competitive process.
Process, yes.
So therefore, your understanding was that in respect of the building of houses during any particular term, 5-year term, it is in order for companies that are on the database to be given contracts to build houses without any further open tender process. Is that correct?
That is correct, Chair.
Yeah, okay. Mr. Pretorius?
Yes. Well, let's, from our point of view, just summarize that because your most recent answer does not accord with the law, but I think you've foreshadowed that by referring to the amounts contained in Treasury regulations and the limits imposed by that. But the first proposition is pressure of time for the completion of a particular project is no reason for departing from the prescripts governing procurement. There are some provisions that allow emergency procurement processes to take place, but they're very strict. Time alone is not sufficient. Are you aware of that?
Yes, I'm aware, Chair.
Right. Secondly, the Treasury regulations deal with databases, but they specify that above a certain amount, I think at the time it might have been 500,000 Rand,
Yes, that's correct.
you still have to, despite your presence on a database, be subject to a competitive bidding process. Do you know that?
I know that, Chair.
And many of the allocations that we are dealing with here exceeded that amount. Correct?
There are those who exceed, yes.
So despite your presence or listing on a database, and perhaps I shouldn't use the word list because I'll come to that in a moment, a competitive bidding process may yet be required in relation to a particular contract over 500,000 Rand. For those under 500,000 Rand, different provisions apply. You're aware of that. You mentioned it.
I thought I'd clarify myself that my understanding of this process is that, let's take a company, will tick all the boxes of being able to be awarded well beyond 500. The company will tick all those processes during an open tender. As this is explained, the difference will be, instead of looking for 10 companies that are going to build 100 houses, there will be 150 companies that have gone through the same process that the 10 companies have undergone. Meaning they tick all the boxes. They then are as reserves of any project that comes. That's the explanation I got, Chair, which to me, as I'm seated here, becomes slightly different from a database. Because a normal database, as described by the law, can only be compiled with a particular amount, as the leader of evidence is saying. That I know.
Yes, well, a database is a legitimate tool in the procurement process. The establishment of a database is governed by law and particularly Treasury regulations. But even one's presence on the database does not entitle one to be granted a contract over 500,000 Rand. If that is to happen, there must be a competitive bidding process. That is what the law says.
Yeah.
Your understanding of it, we can look at in the course of time and assess it. But what I do want to put to you is that there appear to be two issues that may have been conflated or confused. The first issue is a list. That is an established list from which you believed as a department contractors could be appointed. A database, says Mr. Mokoena, is something that precedes the compilation of a list. There would be an advertisement, and I'll give you an example at a moment, to contractors. That advertisement would say, please give us any interest you may want to express in getting work. We will then put you on a database, and when there's a need to allocate work, we will contact you and invite you to bid. And if you'd look at page FS 12, 372.23, you'll see an example of such an advert. Hey, you don't want to go there, you
I've
trust
seen
me
it,
on
Chair.
that. You've seen it.
But the question becomes in this commission. Let's take the nearest. Between the year 2004 and 2009, was such a process of the expression of interest used? Even in terms of the evidence given here by other people who were called here, I think this issue, we must, in my own understanding, Chair, is an issue that seeks to address the inadequacies which were there, which we must accept in this commission, that in terms of the law, there were issues that were not followed properly. And at a particular time, these issues, there were an endeavor to try and correct these issues. I would accept that.
All right. In fact, that's what the department went to court to establish in order to review the contracts given. You know about that. There's been extensive evidence. But perhaps that comment is unnecessary. The evidence is on record. Doesn't require your comment. I'd like to move to another topic.
Sorry, Mr. Pretorius. Maybe we should take a short adjournment. I see it's 4 o'clock.
Yes,
10 minutes, and then we can continue.
yes, we'll be finished.
What's your estimate? I'm not putting pressure, I just...
I think we would like to be finished by 5, but I think we may be finished by 4:30.
Yeah, no, that's fine. That's fine.
Thank you.
Okay, we'll adjourn for 10 minutes. We adjourn.
All rise.
Okay, let's continue.
Chair, I'd like to place something on record. It seems that I may have, in fact, probably did put a misleading proposition,
Yes.
and it must be corrected. When dealing with the Rob's construction payment, the payment by Rob's investment was made to an entity called SED Trade, SEDTRADE. This may have been on the instruction of the Premier's office. We don't know that. That may be an inference that might be drawn. But that payment was copied to the Premier's office and to Ms. Chilota, and acknowledgement of that payment was noted by Ms. Chilota in the Premier's office. So that is the correct sequence.
Okay.
You will recall evidence concerning the meeting of EXCO on the 30th of June 2010. And we dealt with the minute of that meeting. You recall that?
Yes, sir.
Mr. Mokoena says in his additional affidavit, and you would have noted that in the normal course of events, if the department reports to EXCO, that report would be signed off by the head of department. In other words, Mr. Mokoena. Is that a correct statement?
That is correct, sir.
And not only that, but the head of department would have been invited to the EXCO meeting. Is that correct?
Yes, that is correct, sir.
Right. The EXCO resolution which we've dealt with refers to a report from the department, but Mokoena says he didn't sign off on any such report, nor was he invited to the meeting. Can you confirm that?
Well, Chair, I think I must say what I've said, agreed with, is correct. But Shodi Mokoena should have also said that before the EXCO, there is a structure called 4HOT. That structure is a structure composed of head of departments and the DG in preparing for EXCO. So if somebody for any reasons is not going to be part of EXCO, they would be part of 4HOT, where an agenda is prepared. They will also become part of the 4HOT after the EXCO to track down in terms of what they needed to make follow-ups and report back in terms of the time frames. So it will not be correct that all this other process, the former HOD would come here and deny. He knew about this meeting. He knew about the outcome of the meeting. And as much as I knew about them, I think that's what I want to deposit to this commission.
Well, we know that the minute mentions a list given to the EXCO for its consideration. Correct.
The
minute
Chair.
mentioned.
Yes, Chair.
What Mr. Mokoena says further, that he never at that time knew of any list, whether for new or existing projects, that had been sent to the MEC, that is yourself, and by implication EXCO.
The question becomes, what did he do? Because if he did not know about this list, and this list was produced by me, and it was irregular, according to the PFMA, he should have objected to this matter and reported the matter. And this matter is only raised here in the commission. Mr. Mokoena knew about all the lists that were there. He supported them. He even participated in terms of drawing contracts for all these lists. Chair. If he had a problem with any of the list, he should have not even participated, because that would have been illegal and it would have formed fruitless and wasteful expenditure. And we all know what the law says about that. I maintain he knew.
You were the one who attended that meeting, though, and made that report.
I was the one who did what, Chair?
Who attended the meeting of EXCO on the 30th of June and made that report to EXCO, referred to in the minute.
I made that report, Chair, and there was a presentation. In that presentation, the presentation, if I'm not mistaken, it's part of this record. It even says the department has gone into a rigorous process to ensure that all the participants that were in that list are correctly there, they have been vetted, and so they qualify. That was the presentation according to the minutes, and I couldn't, without the help of administration, know those issues, because I don't vet any people, I don't do those issues, they are administrative issues.
Right, well, we've been through the lists, how they were comprised, and the existence or otherwise of competitive bidding processes preceding the compilation of the lists. Don't want to go there. I do want to deal briefly, finally, with the affidavit you submitted to the Commission regarding the Housing Act.
Yes, do I want to do what, Chair?
No, I want to deal with it.
Okay.
If I may.
Okay.
The procurement policy required in terms of section 3(2) C capital A close brackets of the Housing Act was, according to our researchers, introduced by the Minister with effect from April 2002. It was added as Chapter 3 capital A of the 2000 Housing Code. That's simply for the record, those references, but did you know at the time you were MEC of that procurement policy?
No, Chair.
And then I'd like to deal with this issue of delegation, because it may be a matter of concern to the Chair to consider certain recommendations to tighten any loopholes that might exist. The earliest reference that we could find, and in the short time available to us, perhaps our researchers need some further work, but in 2013, there was a document entitled Principles of Public Administration and Financial Management Delegations, approved by Cabinet, which stated that any delegation or authorization to exercise a power or perform a duty does not divest the principal functionary of the responsibility concerning the exercise of the delegated power or performance of the duty. Now, we know that in the Housing Act, the MEC has certain duties and powers. Those delegations would in 2013 have been subject to these delegation conditions where accountability would have remained. And we've established that certainly as far as we know and as far as you're concerned, those provisions did not exist before 2013 and may need to be looked at once again, Chair, in relation to delegation and accountability for the functions delegated.
If I may just comment, Chair, I think this issue gels in with what I've said earlier on, that due to some development, new acts were introduced to try and deal with those developments, and I think this is a good example of a that kind of an issue that I've raised earlier on.
Is there anything you wish to add, Mr. Zwane?
Chair, I think I agree that with the ushering in of a democratic government, a number of things had to be taken care of, and the issue of tightening the act, coming with new acts to try and look at the situation that was prevalent at that particular time, became a big issue. And over time, we were able, as government, to plug the holes that seemed to be there unchecked because of legislation. I think that's what I want to put on this issue, Chair.
And finally, and in summary, lest the legal team gives the wrong impression, Chair, we would still rely on the allegations made in the review affidavit submitted by Mr. Mkezi as to the nature and intent behind the advance payment system. But you know about that, and we've put that. Chair, those are the questions.
Yes, Mr. Zwane.
Chair, I just wish to quickly express my appreciation for the commitment that this commission has shown. Under normal circumstances, we would have been given a chance to go and be with our family. It's Christmas time, and we have many other issues. But this commission has taken its work seriously, and I want to say on my part, as I've said earlier on, I wish to cooperate with this commission, and I think I have displayed that. Even this morning, I was supposed to come here at 4. I was called earlier, and I availed myself. I'll continue doing that, even for future, if I'm needed. I did say that the last time I feel very comfortable in terms of how this commission has treated me up to this far. I also want to thank you for having made this time for me to come and clarify those issues that may remain hanging in the minds of people. I have indicated that I did not have anything to do with Rochelle or Blakey. I did not take any instruction from anybody, and I will try in the future to ensure that whatever information I have needed by the Commission will assist the Commission. Otherwise, a blessed festive season for all of you. I hope I will be called in January, not in December. But should it happen that the Commission remembers me during December, I still am committed to assist this Commission. Otherwise, thank you very much, Chair, and the leader of evidence and everybody.
Yes, thank you, Mr. Zwane.
Well, thank you very much, Mr. Zwane. On all the information that I am aware of now in the dealings between the Commission and yourself, the information I have is definitely that you have been cooperating, that you have given this Commission cooperation. So on the information that I have, certainly that appears to be the position, and you are right that you were meant to appear only later, and you were called and asked whether you could come earlier, and you and your legal representatives representative agreed, and we are grateful for that, because there was a challenge which had happened, but because you were able to come earlier, we are going to be able to I'm going to be able to hear another witness, and if you had come at 4 o'clock, there might have been a clash. On the information I know, you certainly have cooperated, and we appreciate that you feel free to express that you feel that you have been treated properly by the Commission. We will always try. Maybe we will not always be seen to be succeeding, but certainly we will always be trying. Thank you very much. As you say, you will still come back because there is still some outstanding business, and
we reserve our rights.
But thank you for all the compliment you have given to the Commission, and we also wish you an enjoyable festive season. We will try and make sure that we don't remember you on the 23rd of December or 24th and call you to come and finish the outstanding business. We'll try and remember you in January or beyond that. Okay, thank you. And I take it that your legal representative doesn't wish to re-examine. Yes, thank you. So you are now excused. Thank you very much. I think I must adjourn to allow the new evidence leader for the evening session to set up, so that then I will come back and I hear the next witness.
Yes, Chair.
Yes, otherwise, from your side, you and your team are also excused.
Thank you, Chair.
And Mr. Zwane's legal representative is also excused. Okay, we'll adjourn for 10 minutes. We adjourn.
I said they're missing.